Hello and welcome to the Benefit Whisper podcast, where we pull back the curtain on healthcare, insurance, and everything in between. I'm your host, Ralph Weber, and today we have an incredible guest, Julie Selesnick, a legal expert who's been deep in the trenches of healthcare lawsuits, and we're diving into some really eye-opening developments, including the big one, the JP Morgan healthcare lawsuit, and what it means for employers, employees, and the future of benefits. So let's get started. Julie, so happy to have you here today. Thank you for taking the time to be with us. Could you start by telling us a little bit about your background and your focus in healthcare law?
Sure. Thank you for having me. Nice to meet you. Sorry about my lighting disaster that just occurred briefly on the side. I'm Julie Selesnick. I am an ERISA attorney. I've been an attorney for about 25 years, and my earlier years were spent doing a lot of insurance coverage work in P&C lines of insurance. I then left that line of work and started doing ERISA plaintiff side work in a class action law firm. And I was mainly focused on pensions for a while, like everybody else in the ERISA world. But about 10 years ago, the head of the group that I was in and we really liked healthcare and wanted to sort of start pivoting in that direction, and realized that many of the things that were happening, on the pension side and that were the subject of a lot of litigation were much worse in the healthcare space, and that it wasn't really being addressed. And we started looking at it, we realized, that the healthcare space was much more complicated and complex than the pension side was, the 401k side, and it was going to be difficult to get in there. But we started trying to do that pre-CAA, and we really didn't have a ton of luck, although we were writing articles about your duty to monitor and how difficult it was in the opaque environment and things like that. And then all of a sudden, the CAA comes out of nowhere like this amazing, little godsend bill that really, I think, has changed sort of employer-sponsored health plans more than anything since the Affordable Care Act, as far as, really changing what employers or anyone sponsoring a health plan is expected to do and what they need to do in order to be proper fiduciaries to that plan. And so since then, we've just hit the ground running, and I've been, my practice has actually grown. So I've been a class action attorney for many years, and currently of counsel at Berger Montague. I develop litigation with the attorneys there, and that's where I sort of work on litigating. And right now I have several lawsuits against insurance carriers, all based on various provisions in the CAA or ERISA that, are arguably being violated. But I also have recently opened my own firm where I do non-litigation work and trying to avoid litigation and help employers and vendors that are trying to make it work in this space and compete against sort of these larger entrenched insurance carriers and PBMs, just try and make it work and get into the, create a more level, fair playing field.
Sure, absolutely. Great. And of course, it's not just the benefits, but specifically PBMs themselves, the pharmacy part of the benefit plan has become a bigger and bigger focus. I remember when PBM pharmacy benefits were about 10% of the total claims. Now, in many cases, they're 21, 25 even. They've become really high and really complex in and of themselves. I read, Julie, it's interesting. I asked ChatGPT the other day, when Cigna purchased ESI, what happened to their profitability? ChatGPT said, well, they purchased it for $67 billion in 2018. Before that, their revenues were $48 billion. After that, they're $153 billion. So they tripled in 1 year.
Wow.
Okay. And of course, with the Affordable Care Act, there was some cap on, overhead and stuff, which doesn't apply with self-insured plans, but still focus said, let's find other avenues of revenue. So I think that's where the PBM started rising. So what do you see as the biggest legal trends in healthcare right now?
Well, ironically, even though all of these massive PBMs that we're sort of going to talk about today and that we're talking about already, they're all owned by insurance carriers, or they own insurance carriers, vice versa. So you've got Cigna has its own, Anthem, now Elevance has its own, although Carelon, I believe, is theirs. United has its own, and, and Aetna has its own. Well, CVS owns Aetna, actually, so that one's sort of reversed. But what's interesting to me is that the trend is not on the insurance carrier and on the third party administration part of that. It's on the PBM. So this
Really?
seems to be the sort of the one bipartisan issue in America is everyone agrees we should sue PBM. And so, you see the FTC suing them. You see states and local governments suing. You see
Michigan.
self-funded plans. Yes, the state of Michigan.
Yep.
They're all over the country for price fixing, for overcharging for insulin, for, all kinds of really antitrust violations and other types of ERISA and federal law violations saying, you're really acting unfairly. And I think it's easier to understand how it works in the PBM context than on the medical side, which is why it's easier for everyone to sort of conceptually grasp, we should sue these guys.
And also, Julie, I think that PBM, a prescription is more of a commodity than a knee replacement.
Yes.
Knee replacement's more personal, or heart valve or cancer or something like that, where you want that doctor of your choice. Whereas if you get the pills from Walgreens, CVS, corner drugstore, Costco, it's just a commodity. So I think it's easier to shop that.
Absolutely. And what you just said is totally true. You can look for prices on a knee replacement right now, but it's still not really clear what it should cost in your geographic area for what your needs are compared to what your prescription for Humira should cost, because you can Google that in 2 seconds, find out what every pharmacy around you will charge and for every sort of health plan or self-pay. So
Absolutely.
there's
and
more
Mark Cuban has helped that a lot with his transparency and with Cost Plus. So let's talk about the JP Morgan case. Can you break down what the lawsuit is about in simple terms for the listeners?
Yeah. And so it's sort of a continuation. It started with the Lewandowski versus Johnson & Johnson case. Then there was Navarro versus Wells Fargo. And now there's Stern versus JP Morgan. And it's the same couple of firms bringing these cases, and they're sort of refining the allegations as they go to deal with what's happening in the originally filed cases, because what has emerged so all of the cases allege, hey, you're not doing a very good job managing the pharmacy benefit aspect of this health plan, and we are spending an excessive amount of money, we the plan participants, because of your bad choices. And so it started in the J&J lawsuit, and what has emerged in those cases is an issue with the people bringing the lawsuits having sort of enough of an injury to have the lawsuit. So it's called a standing challenge. And they've faced these issues, and that happened in the J&J and Wells Fargo lawsuit, where the courts have been like, well, even if what you're saying is true, we don't see how you personally, plaintiff, were injured by this. And so both of those have been refiled, and now we have amended complaints. But this case against JP Morgan, first of all, it deals with that by, these plaintiffs don't have the issues that the plaintiffs in the prior lawsuits had. None of them have reached their out-of-pocket maximums, and all of them allegations that, all you have to do is, we spent $40 when we should have spent $30. That is a concrete injury. And so if you allege that, and you can show that you weren't at your out-of-pocket maximum, which is sort of a in-depth issue that went on in the J&J lawsuit, then that is enough to sort of get over the standing challenge. But what's really interesting in the JP Morgan lawsuit there are some unique allegations that don't exist in the other lawsuits. Specifically, first of all, there's an allegation, hey, you should have known better. JP Morgan, you were involved with various industry groups, trade groups that told you specifically not to do the things you were doing, and you did them anyways. And didn't you also have your own healthcare venture that you started in 2018? And it was specifically to not have to pay these costs, and you abandoned it for your own personal business reasons. These are the allegations in the complaint.
I see. Right.
So they're saying you put your business interests above the interests of your plan participants. And this is a hard one, because any plan sponsor is wearing two hats. They're an employer, and they have business concerns, and then they're a fiduciary, and they have to act in the best interest of the plan participants and beneficiaries, and make sure that, they only spend reasonable amounts of money on things that are for the proper medical costs and to defray reasonable expenses. And it's really hard to balance those two out. And I think the larger the company, the harder it might become if you're entangled in business dealings with the entity that you're being accused of sort of not making a very good deal with. And then there's one other unique aspect in this case, and it's a prohibited transaction claim. And the reason I bring it up is because the Supreme Court just ruled 9-0 that as long as a prohibited transaction in ERISA says, hey, there's a bunch of things under the ERISA statute that you just can't do. You cannot engage in these types of contracts. They're presumptively prohibited. Now, you can come back and show that maybe you were exempt, and that's a defense. But if any one of these things occurs, then it's presumptively a prohibited transaction. And here it is presumptively a prohibited transaction. And this is the first time this has been alleged here, is in this case. And what they say is, it's a prohibited transaction because you are doing business with a company that is a party in interest. It's these party in interest allegations that say you're sort of self-dealing, it's benefiting you at the expense of the plan participants.
Yeah,
so that claim
absolutely.
probably wouldn't get dismissed on a motion to dismiss.
Right. Interesting. A lot of these lawsuits are brought by, former employees who, and hence the class actions. I there's so much to talk about, so much to unpack here. What do you think the ripple affects the most? Who do you think that this affects? Is it employers, employees, healthcare providers, insurance companies? And, the second part of that question is there a different level of fiduciary duty for non-ERISA plans? Is there a difference between for-profits, nonprofits?
Let's start there,
unpack that.
actually.
Okay.
So ERISA covered plans have the highest level of fiduciary duties, known to man. It's a little dramatic, but that's what they say. It's a really high obligation. You have duties of prudence, duties of loyalty, and it's very well spelled out in the ERISA statute what that means. However, states and municipalities and other non-federal governmental health plans are also have very similar fiduciary duties. They just don't arise under the ERISA statute, but they're either state laws that mirror the statute almost verbatim, or there are often trust documents that adopt the same stringent requirements. I've never done any work on behalf of any plan that didn't have sort of stringent fiduciary obligations attached to it. So people that are in charge of managing or administering, non-ERISA covered plans should not feel that they don't have to follow, the rules that fiduciaries have to follow, because they do. And that includes church plans, non-federal governmental health plans, nonprofit plans, anything that might not traditionally fall under ERISA. That being said, there is one difference right now in that only ERISA plans are required by law, which happened under the CAA, to get compensation disclosures from their vendors. That being said, if you are stewarding a non-federal governmental health plan, a municipal or state health plan, and you don't have a grasp on what you're paying the vendors, I think you're breaching your fiduciary duties. You don't just have your participant members' funds that you're responsible for, but the other funds are taxpayer funds. So it almost feels like you should have a heightened duty compared to, everyone else's duty, because these are all public monies, so I think that just because the law doesn't specify that you do this, common sense does. You can't be prudent without knowing what you're paying somebody for the services.
Exactly. And it sounds like nonprofits would fall very close to that level of care as well.
That's right. And some nonprofits are private entities that are ERISA, covered. Others wouldn't be, but no matter what, all of them need to follow, a fiduciary standard. When it comes to a nonprofit, you're using maybe funds that have been granted to you, or, so you're always using other people's money, and you're in charge of not just your employees' money, but whoever is funding your venture. And so you have to act responsibly, prudently, and loyally. Those are sort of that's the common law duties of a fiduciary, no matter what. A fiduciary relationship between a lawyer and a client, between a guardian and their charge, between someone that's responsible for an older person who can no longer make their own decisions. If you're in charge of someone else's money, you have to act prudently and you have to act loyally. You always have to put their interests before your own interests.
Absolutely. So, Julie, do you think that this lawsuit could trigger more cases against self-funded plans or large employers?
Yeah, I do. And I think that these cases, probably the same firms are already readying additional cases to file. And obviously what we're seeing is sort of from what we've seen, I would expect to see more cases against banks or other large entities that might have business relationships with the PBM, if we're going to see similar types of mismanagement claims. But I also think that everyone shouldn't let their guard down and think this is the only type of case in which employers are going to get sued. I think there's another case that's been sitting out there quietly and hasn't been resolved yet that I would be much more concerned about if I was an employer, but it gets like no press and I don't know why. It's the SMO Mayo Clinic and Medica Mutual case. And in that case, the employer, Mayo Clinic, is really on the hook for a lot of decisions made by the TPA, and there are like RICO allegations in addition to breach of fiduciary duty claims. And these are the things that plans have. The allegations in that complaint are the types of things that plans have very little control over. Things like adequacy of the network when it comes to finding mental health providers for your kids. If I'm a self-funded employer, I get what I get with the network that my TPA has. And I don't really have much say in that. I can't say, well, this is inadequate, I'm going to add more mental health providers to this network. And, the takeaway, though, is that you may have to supplement what is you're being given to make sure that the network is adequate, or having things like ghost networks, or, networks of doctors that don't really take that insurance. You don't really, these are things that, again, the employer doesn't often control, but can get sued for. So I would be really concerned about cases like that as well. And I think in that case, you've got a parent that tried to find a mental health care provider for their small child. They couldn't find someone in network. They followed the plan document instructions, but then Medica said, nope, we're not going to charge you an in-network rate. You should have called us. The plan document doesn't say to do that. If you don't follow plan documents, you can have a per member per day fine. So I think there's a lot of other ways that plans could also get sued in the future. I think there's also a very sort of a blueprint case that the Department of Labor brought against Blue Cross Blue Shield of Minnesota for charging hidden fees to self-funded employers. And that was sort of a beacon to employers that, hey, you need to be checking for this. You should be able to do this too. And if you're reviewing your data like a responsible fiduciary should be doing, you should be finding these things and challenging them, because you can't pay undisclosed fees.
Absolutely.
So I think there's lots of potential for future cases against employers, and in this area and in others.
Right. I might be challenging your memory here, but going back, the first one I remember was Calhoun County, Michigan. Do you remember that case years ago? That must have been 15 years ago, or at least 10.
Well, I do know that case, and it actually goes even further back. There's this Lex versus Blue Cross Blue Shield of Michigan. Michigan is really where it all started. I think this law firm, the Varnum firm, sort of pioneered this hidden fee litigation, and they've been doing it ever since against Blue Cross Blue Shield of Michigan in particular, and just saying, hey, you cannot charge fees to a plan that you don't disclose. And that seems pretty basic. But to this day, I've never seen a plan that isn't paying fees that they're unaware of, or fees that they don't have a sort of grasp on. What's the fee and what's the medical cost here? It's all lumped together. And that's exactly what you're not supposed to do.
Exactly. So, Julie, what lessons should employers take from this situation to avoid finding themselves in similar hot water?
Well, where should we begin? I mean, there's a lot of lessons. The first one is, you have to have a fiduciary process in place to make all of your decisions involving your health plan that you're offering others. And that doesn't necessarily mean, not every plan is a huge plan the size of JP Morgan. So I understand that not every plan is going to have a established fiduciary committee in place. Some companies are 10 people or 5 people. So you might not have a committee, but you still have an obligation to act as a prudent fiduciary. And if you're ever going to be challenged on a decision you make, the best thing you can ever do for yourself is to have sort of a fiduciary file that shows how you made important decisions governing the plan. So for instance, if you're ever, if there's ever a lawsuit filed against your plan that says you didn't do a good job managing the PBM spend, we're paying too much for this generic, you could say, well, we went ahead and we did an RFP and we vetted this many, PBMs on our last time around. And we made it clear that we wanted to have a competitive formulary, but here were the offerings, and each PBM sort of controls the formulary and doesn't necessarily let us go outside. So we did negotiate a carve out for blank, or we did as much as we can. You just have to show that you considered the issues, did the best that you could, and tried to make the most prudent decision available. You don't always have to make the right decision in ERISA, and it doesn't always have to be the most cost-effective decision. It just has to be prudent and show that you engaged in a prudent process in getting there. And so that is what is missing, and the reason why is sort of part of a larger absence of intentionality on behalf of almost all employers when it comes to putting together their health plan and understanding what their goals are and how to achieve those goals.
So I guess my consultant told me it was a good idea, isn't a good defense.
It's not a good defense unless your consultant has agreed to assume fiduciary responsibility right next to you and, has their own fiduciary liability policy in place where you sort of giving them the discretion to make these determinations and they're taking on responsibility, but you're still at the end of the day responsible for monitoring any fiduciary that you give discretion to. Oh, I'm sorry, employers. I'm sorry, unions. I'm sorry, other plan sponsors. You just cannot get away from this. There's some amount of involvement that you have to have at the top level to make sure that your plan is being administered prudently and that all of these decisions that are made reflect a prudent process and no disloyalty, no conflicts of interest in using the decision-making process. And right now, I can't think of a plan in this country that isn't rife with conflicts of interest. And I'm sure there are a few, but generally speaking, most plans are just rife with conflicts of interest in large part because employers still don't really have proper compensation disclosures from their vendors.
I'm sure. And I think sometimes you have this fear of messing up where let's appoint a committee. Let's put enough people on this committee so that we can say we had a diverse group of people. But you brought up a key point. It's at the very top of the food chain where the fiduciary duty lies. So there is duty of oversight.
That's right. And so, if you want to do yourself a service as, the CEO, whoever, wherever the buck stops, that person, you need to be trained as to what it means to be a fiduciary. You can't get away from this. And so you need to have some sort of basic understanding, and really better than basic understanding would be ideal, of what your role is regarding offering this health plan. I think that if you look at 401k plans, companies take it very seriously. They understand the risk of litigation because there's been 20 years of that risk playing out before them. But that has led to, that's arguably less interesting than your health plan and more dry.
Absolutely.
But employers have realized okay, this is real liability here and I need to pay attention because I could get sued for this. That sort of hasn't happened yet in healthcare, at least as of right now. Employers are still much more afraid of the vendors, particularly the insurance carrier, than they are of anybody else in the food chain there. And they're more afraid of losing access to a network and thinking that if that happens, the sky will fall. They'll have no employees left. They'll never be able to hire another one and their name will be mud and that there's no way to solve for this. And that seems to be a huge stopping point for most plans to start making better decisions.
Absolutely. Now, of course, the whole concept of controlled group, that started in the pension market. And it wasn't until the ACA that it started applying to health plans as well. So that's, I don't know if that fits into this discussion, but it seems that the controlled group is you're all responsible for all parts of that potentially as the fiduciary.
So yeah, and really, even though ERISA is very obviously much more geared to pension and 401k plans than to health plans, it always applied to health plans. And in fact, some of the earliest things the Department of Labor did to enforce ERISA were go against unions that they thought were sort of had their hand in the cookie jar of the fund, and that there was a lot of healthcare enforcement in that way. And so it really is. And then all of a sudden, what happened, I think what has happened is, what happens in any sort of complex area. This particular area, employer-sponsored health plans, is now so complex that it is almost unregulatable, ungovernable. Plans don't know how to approach it. Regulators don't know how to approach it. They don't really know. There's limited budgets that everyone has, and then, of course, self-funding adds a new layer to this where states try to make some laws that won't be preempted by ERISA, but that might help, consumers in that state, which include businesses and the participants. But, they get sort of fought on these preemption grounds. And it's just really difficult to get any traction trying to be a good fiduciary, trying to be a better fiduciary, and to try and get the support you need from the regulating authorities to let you do that. So for instance, the CAA is great in many ways, but all the burden that comes with the passage of the sort of new sort of disclosure and enforcement mechanisms in the CAA fall on the plan. And there are not a lot of sticks to put against the service providers. and there
Sure.
haven't been to date. And so we've been hoping for additional legislation or rulemaking, and it's just been really slow to sort of help the fiduciaries have any sort of leverage to make service providers act the way they need them to act so that they can meet their obligations.
Absolutely. So, Julie, what do you think are the best practices or legal safeguards that companies should be putting in place right now?
So, the best practices of, first of all, again, I sort of mentioned this a few minutes ago, intentionality. It's talked about sort of in your own life space all the time about how you should try and be mindful, try and do things with intentionality. This couldn't apply any more than it does to your health plan. Like, you need to understand in advance, what are you trying to do here? What is the goal? What are we trying to achieve in this
Right.
health plan? And
Yes.
most employers would probably have the same set of goals. We want to provide the best health coverage possible to attract and retain the best employees we can. And we want to provide it in a cost-effective manner that doesn't compromise the quality of the care. So those are
Right.
pretty basic goals once you get them out. And then you have to come up with a strategy to achieve those goals. I've never seen a health plan, or not very many health plans, go into sort of renewal season with a set of goals or a set of action items that are going to help them achieve a predefined set of goals they have. And if they
Sure.
did, they might do a better job vetting service providers, making sure that RFPs are actually crafted with questions that will bring the answers they need to make sure that they hire the right vendors. So if you keep hiring the same set of consultants and advisors to provide you with the same set of services that you've been provided with for the past 20 years that aren't working, what
Yeah.
is the definition of insanity again? It's sort of, you have to
Exactly.
make some changes if you want
Yes.
things to change.
Yes.
And
Absolutely.
I think that's
Absolutely.
where employers have to start. They have to come up with a plan. They have to have a set of understanding of how will we achieve these goals, and then go into renewal season with a sort of a consultant that understands this, that is unconflicted, which means they're
Yes.
not accepting indirect compensation from any other service provider that they're going to recommend. They're fee for service from the employer side only. This is what employers often don't understand, is that there's really no one sitting on their side of the table with them when they're doing these things. They often are relying on advice from a party that is going to receive compensation from one of the service providers that they recommend you choose.
Right.
And that's a conflict. I mean, in fact,
Self-dealing.
yeah,
Yep.
exactly.
Yep.
And
Absolutely.
so do you remember Elliot Spitzer?
Yeah. Then yes. Yes.
I never stop talking about this, and I do this like all the time. It's great. He was the Attorney General of New York, and he ended up
Yes.
going down in a flames in a scandal. But before
Sure.
that, his big thing, his big claim to fame was that he was going after these huge brokers. And it was, you might recognize some of these names: Willis Towers Watson, Marsh McClanahan, Mercer. And he was going after them in the not healthcare space, in another space, saying, hey, you're inappropriately steering customers into clients that are going to give you money if you place them there. That's fraud. That's a kickback, and you
Right.
can't do that. And he ended up entering into these huge, almost $1 billion settlements. This is 20 years ago with the biggest brokers. And part of the agreement was that they would abstain from that behavior for 5 years. I don't know why you only have to
Only
follow the
5
law for
years.
5 years, and that would be part of it. But that's how it was. So just last week, the Department of Justice filed a lawsuit against a few brokers that I'm unfamiliar with, but they're in the Medicare Advantage space in the individual marketplace,
Right.
and against Aetna, Elevance, which is Anthem, and Humana. And it's the same set of allegations. It says,
Wow.
hey, these brokers are steering the clients that are relying on them for help just to those three insurance companies because they're getting kickbacks from them. And there's other even worse allegations that they're trying to discriminate and not get people into those plans that look like they were going to cost a lot of money, that were already
Sure.
disabled, things like that. But this is what happens in the employer-sponsored healthcare space every day. Your broker
Yeah.
is probably getting compensated by your TPA, by your PBM. And if you don't know if that's the case or not, you're already not living up to your duties as a fiduciary. So that's the first step.
Exactly.
The big answer to say the first step is figure out what you're paying your service providers and who's
Yes.
on your side and who's not.
Right. Absolutely. How do you see healthcare litigation evolving over the next, let's say, 5 to 10 years?
So I think there's going to be a lot more of it. I mean, obviously the climate in the country is that everyone is fed up with the continuously rising costs, the ever rising costs. And I don't think this definitely is one issue that is a bipartisan, all partisan issue. You see it with, it really isn't political. Everyone's aggravated, understands that there is a huge amount of fraud, waste, and abuse that exists in this space, and is sick of it. It's a topic of these huge news exposés. You see ProPublica is like really focused on and the New York Times did a series on multi-plan and sort of out-of-network repricing. These are dry issues for the American public, but all of a sudden they become these huge op-eds and everyone's talking about them on the Sunday shows and Congress is into it because everyone understands that they're sort of being screwed, but they don't, and they want to know how. And so anyone that's willing to shed light on it becomes very interesting. And the more that people share their stories and the more that companies share their experiences, and, instead of sort of putting your head down in the sand and saying, I'm just going to continue on this way and hope that I don't get bothered, you don't want to do that. It's not in your interest, nor is it in your participants' interest. The more you lean into sort of doing a better job, first of all, you're going to be a better fiduciary, but not just that, you're going to be a better procurement person and you're going to buy better health insurance services. And when you do that, you save money and you have better quality health care. So it's like win-win when you begin to behave differently. But it's, just like with everything, I can tell myself every Sunday night, I'm going to eat right this week, and I'm going to start this. I know what I'm supposed to do and I know how to make it better. You just have to get up the will to do it. And I think that what I see happening is the more litigation that happens that unfolds over the next several years, the more will employers are going to find to do the right thing.
Yeah. And as much as I hate to say it, Julia, I think more people have to feel it before there's enough, motivation to change.
Yeah.
A lot of people probably think they're not necessarily that they're above the law, but it'll never happen to them. JP Morgan is huge. Wells Fargo is huge. We've only got, 15, 20,000 people. We're not that big. It's not going to come to us, but it will.
It will. And, you might not get sued in some sexy class action lawsuit, but you still might get sued by a participant. Do you want that? It's still going to make the paper. Everyone in your plan is still going to know that happened. That is going to also bring attention from the Department of Labor, or if you're a non-ERISA plan, from Health and Human Services and other state regulators. Yeah. So there's sort of not being worried that you're going to be the focus of a splashy class action is really the wrong approach, because even a one-member lawsuit against your plan for bad behavior can be devastating to your company, to your reputation, and to future enforcement action.
Exactly. And you just said a key word. I mean, if it makes the paper, if it hits the paper, what's going to happen to your reputation that's taken 20, 30 years to develop could be gone in 2 days.
That's right. And, I understand, and I do understand from the employer's perspective that it's hard. And they're like, I am not a healthcare professional. And so I don't even understand what I'm supposed to be doing. But it's not hard to figure out what you don't know and surround yourself with the right people who can help you know, right. And this is what CEOs, this is why you're the CEO, right? Especially in the C-suite. And this is where this is supposed to be happening. And that's another part of the problem, I think, with employer-sponsored health plans. HR is fantastic, but their job is to implement policies that come from the C-suite. And when it comes to healthcare, they're out there oftentimes like signing the contracts, doing the RFPs. This is not what anyone went to HR school for, is to run a health plan and to do things like this. It's much more in line with what CFOs do and with procurement and leadership practices. And so the place where the contracts are being decided has to shift from HR into the C-suite. And if companies put as much effort into the contracts they sign in the health plan as the contracts they sign for buying paper, buying pens, things like that, which are really closely scrutinized to make sure that we're not paying 1/10 of a cent more than, what another competitor would charge. Nothing like that occurs in healthcare, and it should. The procurement practices shouldn't be so different.
And of course, Julie, isn't it who is it that are the named fiduciaries in these lawsuits? Is it the benefits manager, or is it the CFO, CEO, CHRO?
Unfortunately, it's all of the above. And so the benefits manager, this is particularly unfair, is like, okay, I'm here and I am this mid-level person not making millions of dollars a year. And now I've been individually named in a lawsuit. So that's another thing is every company should have a fiduciary liability insurance policy. And you should make sure that not just the CEO and the company is named, but every single person that might have any fiduciary authority that works for you. And it's really the company's responsibility to defend and indemnify them if anything does happen, because it really isn't fair to expect the human resources people to defend themselves in a lawsuit or to even be named in a lawsuit, and so companies really have to take a more proactive approach in, again, being intentional. And that intentionality starts with the same way they make every other corporate decision. What do we want from this? What is our budget? How are we going to make it work? What is our list of action items? And all of those things have to happen before HR gets involved. That's how.
Absolutely. And I think you're sort of have partly answered the next question I was going to ask, which is if you can give one piece of advice to benefit managers, HR leaders, or even CFOs that are listening today, what would it be?
First, it would be take a deep breath. Everything is probably going to be okay, even though this is probably an alarming conversation. But the great news is there's nowhere to go but up. You are pretty much at rock bottom, all of you. And, you're not managing your plan well, and there's not a lot of involvement where there should be. And no one's expecting you to fix it overnight. So take a deep breath and put together a committee in the C-suite that says, what are we going to do in the second half of 2025 to make our health plan better and more compliant with the law? And how are we going to infuse better procurement practices into our future of our health plan? And then come up with a 5-year plan. What will we do in 2026? What do we want to see by 2030? No one's expecting you to go from being where you are today to being a model plan overnight. It's not possible. And you also there are these structures in place in the market that are going to prevent you from doing some of the things you want to do. And that's just a reality that exists right now. But it doesn't stop you from deciding what kind of plan you want and figuring out how to get there and start moving towards that in a fiduciarily sound, prudent way. And so that's what you do. You sit down and you come up with a 5-year plan, and then you figure out what's our first task. And our first task, we're going to document what we did and why we did it. We're not going to document the minutia, but we're going to make it clear the process we went through to get from A to B, so that if we're ever asked about it, we can show that we engaged in a thoughtful process to get where we are. If you just start doing that and doing one thing at a time in conjunction with an overarching plan, you're going to end up with a much better health plan.
Excellent. Is there a financial benchmark you should be looking at for spending, for example, or is that even relevant?
I think it is relevant. And I think benchmarking is sort of what's missing in the healthcare space that's been super instrumental in cleaning things up on the 401k side. And only now are you starting to see benchmarking tools emerge with these sort of transparency laws, not just the CAA, but also the transparency and coverage and hospital price transparency have also put a lot of pricing info out there. So it's still not, there's most pricing when it comes to PBMs. And so, and if I'm a plan and looking at all these lawsuits alleging PBM mismanagement, the first thing I'm doing is making sure that whoever I am using as a data vendor, which I'm sure you all have, has some sort of dashboard where they're looking at the prices we're paying for drugs versus the prices others are paying for drugs. And what do we need to go back and talk to our PBM about? What's out of whack here? Especially if you have if you're in a traditional deal where the prices are rolling and changing, monthly, you don't want that. You want consistent. Mark Cuban is right. And the other sort of transparent PBMs, Capital RX, there's a lot of them where it's just the sort of NADAC pricing, cost plus. They tell you what it costs. They add a fee. That's what you pay. That's the easiest way to understand the spend and to make sure that there's not a lot of sort of shenanigans and spread pricing going on throughout. And I would say spread pricing is sort of the scourge of health plans. And it happens in the PBM side and the TPA side. And what it means is you think that the price you're being charged for something is the price that's going to the person selling it to you. But what's happening in reality is that there is a middleman, and it could either be the PBM on the drug side or the TPA on the medical side that takes in one amount and puts out a different amount. And those are not the same amount. That is what the focus, that is where focus needs to be placed, is figuring out, I want to know that if I was charged $165 for a Band-Aid, I don't know why I picked such a low number, sure. That you then paid $165 to this facility for that Band-Aid. And if I can't show that, if I can't review that in the data, I need to understand why. And so everyone should have a data vendor. So your duty to monitor is something we didn't talk about. And this is really where the Department of Labor has spent a lot of time doing enforcement, and where all of these cases have allegations that you're not monitoring, the vendors properly, and nobody is. And that's because the vendors make it really hard to do it, but you still have to do it. And so that's sort of, you can deal with this on the front end. Like, for instance, when you do an RFP next time for your TPA or PBM, you say, this is the kind of data access we require. Don't answer this RFP if we are not going to be able to have that.
Right.
Explain to us how the data transfer is going to be made, what requirements you're going to put on our business associate, that we're going to hire to review the data, because here's what the law says and here's what we expect. So the more you do in the RFP and contracting process, the more you can control what rights you have. And that's another place where there's just been zero intentionality by plans. They just sign these administrative service agreements and PBM agreements like they're, like I sign the terms of service when Apple updates my phone every couple months, and I should read that, but we got to read these. These are like huge, important documents. And if you don't want to read it, you need a lawyer to read it, or somebody that can read it and understand it. But you're signing away a lot of things that you shouldn't be signing.
Absolutely. And Julie, I mean, we could go on forever and ever, but anything that we've really missed pertaining to what we've discussed today?
I don't really think we've missed much. I think it's all about just having your end goals in mind. So coming up with your goals and then coming up with a process to achieve those goals. And that understanding that process begins with who you're getting your advice from. That is really important. And so if you have a broker you love, that's great. Do you have a compensation disclosure from that broker? Are you positive that broker is not receiving indirect compensation from any of your other vendors? If yes, proceed to step 2. If no,
absolutely,
you need to already figure out, this might be a conflict of interest for my plan. I have a duty of loyalty. What should I do about this? So that's where you have to start. It's baby steps. It's one thing at a time. It's sort of like learning anything new. You have to do one step at a time, and everyone just doesn't want to deal with it. And so they'll sign anything, they'll do anything, and assume it's going to just, as long as I have a semi-flat spend, that's fine. And, they don't, that's not fine. And you really don't have a semi-flat spend, because we've spent sort of 20 years shifting costs onto employees. That's not a great way to manage your healthcare spend. And it's certainly, if we manage the spend better, stop loss premiums come down.
Right.
Stop loss premiums are the second largest cost probably in your plan right now. So there's a million ways you can make your plan cheaper. And being a better fiduciary is going to save you money. So these two things are inextricably tied.
Absolutely. Well, Julie, thanks for being here Julie, thanks for being here today. Before we wrap up, if folks want to learn more, follow your work, get in touch, what's the best place for them to find you?
So if you're interested in solving problems before they fester into litigation problems, you can find me at healthplanlegalcounsel.com. If you have an issue that is really already sort of, it's going to require litigation, or you need to discuss sort of taking adverse action against a vendor, you can reach me at Selesnick at bergermontague.com. So I am of counsel to Berger Montague, which is a well-known class action law firm. And I develop cases against usually insurance carriers that are acting as TPAs, and against PBMs and other large sort of entrenched interests in the employer-sponsored healthcare field. But I also, in my health plan legal counsel firm, spend time working with plans that want to make better plans and want to avoid litigation and really create better plans. And it's fun when you do decide to make a better plan. You can do all kinds of things. You can design different plans. You don't have to just accept a cookie cutter plan that an insurance company offers you. You can actually design a benefit plan that does the things you want it to do. So depending on how much appetite you have to sort of lean into something new and try new things, the sky really is the limit for what you can create.
Absolutely. Well, thank you so much for sharing your insights today. Healthcare lawsuits like the JP Morgan are really reshaping the landscape, and your expertise helps us to make a lot of sense out of it. So to our listeners, stay tuned, stay informed, and stay empowered. I'm Ralph Weber, the Benefit Whisperer, and if this conversation sparked something, please go ahead, subscribe, like, and share the episode, drop a comment, and you can reach me, ralph@com, or call 832-924-3330. And until next time, take care and keep asking the hard questions.